All right, I think we're going to get started. Good morning, everybody. Thank you for coming. My name is Brendan Cohen from the Stanford Technology Law Review. I want to just say a couple of very brief things this morning before we begin. First, thank you very much to the Stanford Center for Internet and Society, especially Professor Barbara Van Schrebeck, Ryan Kalo, Tony Salzone, Julie Ahrens, and Elena Adolfo for all their help in helping me choose the topics for this panel and for helping narrow those a bit and helping find speakers. So we would not have been able to do this event without their help and support. So thank you. And additionally, I just want to make a quick announcement that this year is the 15th anniversary of STLR. And so we are having a reception tonight from 5 to 6 p.m. Just across the courtyard in the new Newcomb building in the faculty lounge there. You are all welcome to come. And it is made possible thanks to the generous support of the Palo Alto offices of Baker and McKenzie and Morrison Forrester. So we are very grateful for them for that as well. So I'm going to turn this over to Julie Ahrens for a brief introduction, and then we will begin. So thank you.
And thank you, Brendan, for putting together this great conference today. And my name is Julie Ahrens. I'm the Associate Director of the Fair Use Project here at Stanford Center for Internet Society. We're excited to be your host, and again, thank you for coming. And we are really thrilled and thankful to have so many outstanding panelists here today. We have leading First Amendment and privacy scholars, attorneys in private practice, representatives from entertainment industry and from internet companies, public interest lawyers, as well as journalists. So, and they're all here today to share their diverse perspectives, wisdom, and experiences on questions that really are at the forefront of lawmaking and policy debates today. That is, how are we going to grapple with the challenges and opportunities for free speech in this digital age of quickly changing technologies and capabilities? We will explore these issues in 3 panels today. The first panel discussing the challenges of privacy rights and free speech. The second exploring First Amendment architecture and its role in ensuring spaces for speech, both digital and physical spaces. And finally, a panel on free speech and copyright, specifically looking at the SOFA and Protect IP debates that are obviously so timely. So we welcome your participation, and we look forward to the many conversations we are sure that today's conference will spark. So thank you all for coming, and so let's begin. James.
Thanks, and thank you all for attending today. I'm James Temple. I'm a technology columnist for the San Francisco Chronicle. I think we have a fascinating and topical theme to kick off the symposium this morning, taking forgetting seriously, or the right to be forgotten online. And of course, the European Commission just late last month came out with its long-awaited privacy proposals, which included a right for people to demand that their data can be deleted online, as well as some pretty hefty fines for companies that fail to follow the code. I think we've seen some privacy advocates in the U.S. call for similar rules, but there's nothing like the same kind of momentum behind such rules here, in large part because of the far different perspective here on where the balance should be struck between free speech and privacy rights. In some ways, we've had these kind of incompatible legal frameworks that have coexisted and diverged for a long time until the internet came along and kind of threw a bit of wrench into it all. So the panel this morning includes Franz, a law professor at Georgetown University, who wrote the 2009 paper, The Right to Inform versus the Right to be Forgotten, a Transatlantic Clash. Lothar Determann, a principal with Baker and McKenzie in San Francisco, focused on intellectual property and international law, and important for our purposes today. He's certified to practice law in both Germany and California. We have Patrick Ryan, who's policy counsel focused on open internet for Google. Michael Fertik, the CEO of Reputation.com, which helps people get their online profile in order even without a right to delete. He's also a graduate of Harvard Law School. One of these things is not like the other. I seem to be the only one without a law degree. but I'll do my best to ask the right questions to keep this going on, which is really all we journalists do for this anyways. So to start off the discussion today, we've asked Franz to give us a few-minute overview of the European perspective on the right to be forgotten in the sort of historical context that got us to the point of those rules being proposed late last month. So yeah, please take it away.
Thank you. I'm delighted to be here. It's a great pleasure and honor to participate in this very promising symposium. As James just mentioned, I will try to sort of put this right to be forgotten in perspective. Indeed, last month, as you know, the EU proposed to reinforce data protection, and in particular to provide internet users with a couple of strong rights that would entitle them to gain more control over what happens with their data. And at the core of the proposal, it seems like indeed we have a right to be forgotten that is now mentioned in the proposal, a right to delete under certain circumstances information that is on the web, and also, as I see it, a reinforced right for consumers to control, to know what data people out there have, merchants in particular. Now, this bundle of rights is generally called the right to be forgotten, and I guess one should perhaps clarify a little bit what we mean when we talk about a right to be forgotten. There are many forms in which this right can be given. Overall, I think in part it blends or it merges with a very common understanding of a right that's always been engraved in privacy law in Europe. There are stories about me that belong to the past and that entitle me to have removed from public sources. There is an entitlement rooted in a certain conception of private life that entitles me, former crook, to no longer be considered or to be talked about. So what I'm trying to suggest is that, in a way, this right to be forgotten that has acquired much publicity because of this new proposal on the European level is something that's very old and very common and very rooted in the understanding that we have of what privacy means. Perhaps a few preliminary remarks. I often hear people say, well, this is so vague, how can you enforce such a thing? I would want to stress the fact that the proposal just made by the EU is a project of a directive. It's not applicable law. It's law that will compel the member states to implement the directive and to adopt the rules that they see fit. So let's not look for something there is not in this proposal. These are not rules that are supposed to be directly applicable. So if we wonder about precision or enforcement, that may come later on. It's not necessarily to be found at the present stage. The second thing I want to, or that I run into, of course, is the question of enforcement. How can you enforce? How can you transform the content of the internet once the story is out there? How do you make it possible to have it deleted, to have it removed? How will you avoid that Google will keep on producing information that is no longer relevant? Well, I'm not a no clue about what can be done. I just want to believe that it shouldn't just be a question of money. I think that we should try to do our best to match are representations of what privacy is about, regardless of the technology that is being used. I'm struck by the fact that we are able to make Google make things appear at a certain level of information. In other words, not in the top pages, but at the end. One can even pay for that to be done. I think one could think of creative ways in which one could say, look, this is no longer relevant. This needs to be taken away. Might cost money, but I think that spending might be actually meeting the expectation of certain people whose concept of privacy is different from what it is here. I guess one thing that is very important to grasp and then to debate is the fact that the Europeans do not just believe in free speech. They have also promoted the idea that private life, one's intimate life, is constitutionally protected. And so there is no such thing as a free speech that would unilaterally make all other entitlements subordinate. The European Court of Human Rights regularly engages in balancing out the interest of society to be informed against the interest that an individual might have to be left alone, to be respected in his or her private life. And maybe one more thing, this entitlement is not only directed against the state. It's not just that the state could have used its position and do things to you that would invade your private life. This constitutional entitlement also means that private actors may be restricted in their ability to intrude and to interfere with your life. So, back to the right to be forgotten, there's an abundant number of cases in which courts have engaged to decide whether an individual in certain circumstances would deserve a right to be forgotten, to be left alone. And I guess one of the objections I often hear is, how can a judge do that? How can a decision be made about, when a person deserves to be left alone and when a person does not deserve to be left alone because his or her story is still interesting? I think there are ways that we could trust the judges to do that job, to do that balancing job. We trust judges to tell us what negligence is. We should be able to trust them to draw the line where public interest deserves information and where it no longer deserves information. Let me give you a little story that happened not very long ago in Switzerland. A former member of a gang had gone to jail 20 years ago, 25 years ago, was a very heavy-duty gangster, did lots of bad things, including robbing banks, which in Switzerland is not a good idea. He spent at least 15 to 20 years in jail, where he learned to become a computer analyst, comes out of jail, gets hired by an American firm, makes a solid income, is respected by his peers, finds a life, is married to the woman who actually helped him get a job in the firm, and one day, one of his former crook colleagues is caught into doing criminal activity again. At which point, a journalist finds nothing better than to go after the story and not only tell us what is happening today, but of course give the full list of the full names of all the former members of the gang. The guy got completely destroyed. I mean, he makes a nervous breakdown. His entire effort to be rehabilitated is wasted. He loses his job and finds him without employment. I have to, my thesis is that I do not see the point of making this story public. Maybe it's interesting to know that this former guy is now rehabilitated and leads a law-abiding life, but there's no interest in publishing his name. There's no interest for the public to be able to trace where the guy comes from. Anyhow, I'm going to leave it at that for the right to be forgotten. I would just want to add one thing that seems to me very important. When I give information to my bank because they want to know if they can give me a loan, I do not expect my bank to go about and use the information and sell it to other merchants. That's what the directive is going to try to control. And I think, to me, as a European, it seems like a fundamental entitlement. I am happy to get naked and show Amazon what I buy. And they can tell me, hi, Franz. Are you Franz? Oh, well, if you are, we have a couple of recommendations, which freaks me out, but I can live with that. I cannot live with the idea that I do not know to whom Amazon is selling my information and my taste and my way of life. At least if that's the way commerce is supposed to function, then I do want to know, and I want to be able to get after Amazon and tell them, look, now you give me back, or you tell me to whom you have talked. This is in the way of introducing the new proposal. Thank you very much for your attention.
Thank you, Professor Werro. And now we're going to ask Lothar to provide a bit of a counterpoint for the U.S. perspective, kind of laying out the legal framework and how we got to some different points here.
Yeah, thank you very much, James. I'm very honored that I get to represent the U.S. perspective. As a recent immigrant from Germany, I usually get invited to these kinds of things to defend the European perspective. But since we chose a Swiss scholar to represent the EU here, even though Switzerland hasn't joined yet, because of bank secrecy and tax planning, I think it's just fair that I get to say what the US thinks about this proposal. And I'm glad that I get to represent the US because what a pathetic right this right to be forgotten. Here, out west, we fight for a right to be remembered. We want our 15 minutes of fame. We come up with new technologies. We create new data, social networking. We're running at fast pace, and all Europe can think of is to be forgotten. And I think one point Professor Werro made is that it's a very old right, and I think that's the one thing Europe can still claim for that it's something that the US, I think, has way overtaken. I think the European position on data protection in general is not so much based on privacy, but on the idea that the automated processing of data is inherently dangerous activity and need to be regulated. And that's what was done in Europe. It started in my home state of Hessen in more than 40 years now. And it has created a regime that requires the minimization of the automated processing of data. The original reason for that was a fear that George Orwell's vision could become true of the glass citizen that is controlled by the government or by large corporations. And of course, here in the United States, we know that that would never happen to us. Nobody would spy on us. The government wouldn't do such a thing, and therefore we do not follow this approach. We looked at this too in 1974. There was a bill in front of Congress that reads just like the European directive, and we decided against it at the time. We said it's not clear in 1974 that this is going to be so dangerous, and we decided that it's more important for free enterprise and free speech that we will not follow this regulatory approach. Instead of having this omnibus requirement of data minimization, we will have specific sectoral laws that fight particular evils. One reason, free enterprise. The other one, free speech. Professor Werro gave an example here of this crook who was rehabilitated, and then he was uncovered and
had his name in the press. Our answer in the United States to that would be, it's great that that was reported. It might have, for this individual, caused some pains, but in the end, the public saw his personal development. The public can discuss whether it is fair to let him escape his past or not, and that's a good thing. That will lead to an increasing amount of opinions and information in the marketplace, and people can form their opinion. If we always keep it secret, that people can actually get out of prison and be better, people will never have an informed discussion about prison reform and sentencing and so on. The death penalty may prevail in this country if we don't talk about these things and put it on the table, that people can actually be reformed. So that would be our answer. We would say more information is good, information is the answer to bad information, and the free marketplace of ideas will lead to the same and better results actually than to just keep things secret after a while. Now, what have we done? We've passed a bunch of federal laws. There's HIPAA on health information, there's GLB on financial service information that covers a little bit what you just mentioned, the fear that banks would share information. There's also the Fair Credit Reporting Act that deals with the credit reports that can influence a person's life here. We have rules on a state level that you cannot base employment hiring decisions on credit reports anymore in some places and so on. So we are also addressing particular evils that are coming out, and we have a very fragmented privacy law now here in the United States, much more so than in Europe. In Europe there is this one directive that is implemented with some changes in the EU, and by the way, the new proposal is a regulation. It would be directly applicable to the member states. I have it right out here. But the European law is not as fragmented as a result, and Switzerland, even though it's not part of Europe, it has mostly kept up with the rules too, in order to be able to do business with the neighboring states for a primary reason. Now, what have we done on that particular example that Professor Werro mentioned in terms of sharing of information between Amazon and others? Here in California, we have a law, it's called the California Shine the Light Law, and it requires companies to disclose if they share marketing information with others. And you will see on websites of those companies that are compliant with this, that they'll have a little section that says your California privacy rights. And if you click on it, they will disclose to you who they shared with in the last year. Not everybody is compliant with. There's a bunch of class actions are pending right now, but that is one example. And I can't list all the laws here. I just want to make the point that we do address abuse and problems in this country as well, but we don't do it with this regulatory approach where the basic line is it's all prohibited unless you have some specific permission for it. What we have in addition is privacy torts. They're as old as Europe, and they come from parts of Europe, namely the UK. And some of these have developed or be enforced by an article that was written about a lot of years ago as well. And it has a number of things in there: intrusion upon seclusion, public disclosure of private facts, and so on, that would technically also read on this right to be forgotten. And there's been cases where somebody had disclosure of private facts made that at the time seemed appropriate because the person was one of public interest, and then 20 years later they were dragged in the press again with some facts. And courts have also in this country decided that under such extreme circumstances it's possible that somebody who had their private life dragged in the public eye when they were really a public figure can, after 20, 30 years, perhaps not, can withdraw and make a decision and not have their private life dragged out. But the way we're protecting it here, again, is just to protect against extreme cases of abuse and the balancing of public interest in information. Free speech often comes out at allowing the disclosures, and in any event, there has to be a reasonable expectation of privacy to start with. So if somebody has posted something on Facebook or posted something on Google, or a friend of them posted something, and this is out there, then the reasonable expectation of privacy usually doesn't exist anymore, and it will stay in the public, and it would probably not, with any of these torts that we have here, ever be withdrawn. These torts would work towards not having new information perhaps disclosed again if somebody is not a figure of public interest anymore. But there's certainly a difference in how that would be treated. In addition to that, we have relatively strict consumer protection laws Sometimes when I moved here to the US 15 years ago, it appeared to me there wasn't as much. I thought also that the European misconception, I think, that there isn't that much consumer protection law here. There is, in the area of advertising and so on, the law is less paternalistic and expects people to understand that certain statements are more fluff than real information and so on. So there's less censorship here. But there is consumer protection law, and the FTC has already 10 years ago come out and said that every company that collects information on the internet that they have to have a privacy statement, a disclosure and so on. And they're very actively enforced if companies were saying something in their privacy statement that did not announce. But with our principles of free enterprise and free speech, if a company goes out there and says, I will take your information and I will disclose it to everybody else, then they can do that as a general baseline matter with some exceptions. Now, where does that lead us on the comparison to this right to be forgotten with Europe? I think it would be, from the US perspective, it would be very alien to our concepts. I think we would think it is far overreaching. We would also think that the various European attempts in recent times to basically go against Web 2.0, German privacy offices, representatives of the government have publicly said Web 2.0 is basically illegal under German law. And there's an onslaught against any advertising finance business models with the cookies regulation. And this right to be forgotten is in that same theme, basically opposing the news services, the internet economy, and basically trying to regulate it with immense upcoming costs for the providers. What would that mean? Somebody will have to pay for it, and if the Europeans think that it can't be paid for with advertising, and it cannot be, and there will be additional regulatory burdens by imposing this regime, then somebody will have to pay for it. They will have to be paid for services. Maybe these paid for services will develop in Europe and will be very successful, and then we will be able to benefit from them as well here in the United States. But I think in the meantime, the answer to the right to be forgotten from the US would be clearly a no thank you. And we would probably think that in balancing the interest of free information and free speech and so on, we need to uphold our position very strongly and defend it against the regulatory approach that appears in Europe. My personal views on some of these examples, and Eric Schmidt has said this publicly, he said, you know, with all this information about people on the internet, when our children are 30, they'll have to change their names. I'd say, I have kids that are 7 and 9 and they're just getting interest in the internet. My hope is when they're 30, there's so much dirt on everyone on the internet that we stop being so hypocritical, and that the information wins in the free marketplace of ideas, and that they don't have to worry about this anymore, because in all their peers there's the same kind of nonsense out there. And I think that summarizes the U.S. position.
All of them. The ones that are my customers.
That summarizes the U.S. position according to Lothar.
Thank you for that. And with that, with those helpful overviews, we're going to sort of kick off the panel proper now. Patrick, as the Google guy on stage, you have sort of the privilege of doing that industry perspective.
Okay, that's great. Thank you. I think I just have a couple slides to show. I don't know if you can turn on the projector. So while you're turning that on, let me just go ahead and introduce myself. My name is Patrick Lai, and I'm Policy Counsel Open Internet at Google. I've been with Google for about a year, and I, for the past several years, have split my time in academia at the University of Colorado at Boulder, and in private practice. Before joining Google, I spent most of my time in the telecommunications industry doing government relations work. My area of expertise at Google is very general in terms of policy issues, defending the open internet on a broad array of topics. I am not a privacy specialist. We have a team of people who deal specifically in privacy. And so if we really get into very detailed sort of issues around privacy, that's just not my area of expertise. And I do need to give of course, a disclaimer. As a large publicly traded company, there are a number of things that I'm unable to talk about, forward-looking statements. And there's also, as you might imagine, a number of cases and controversies and litigation that Google's involved in, and I'm unable to discuss those topics. So having said that, let me just dive in. This is I'm still a commuter from Denver. And I work in Mountain View during the week, but I go home to my family on the weekends. And so technology isn't just important for me because of my paycheck. It's also very important to me for my communications with my children and for keeping in touch with my family while I'm gone and to keep the distances as close as possible. This picture here on the screen is of my two little girls. Carolyn is 7 and Gabby is 4. And I just love this picture because it's out in front of our home in Denver, and it shows really their personalities. Gabby's, really just a fast charger, and Kara's back there, very disappointed, but she's always been a thinker. So how does this relate to the right to be forgotten? I had a really interesting experience over the course of Christmas break. When I came downstairs, and we have a little area in our house where there's, if you have mail, it goes into sort of an inbox. If you have something you want to send, it goes into an outbox. And there was a letter in the outbox from my daughter, Carolyn. And it had a pre-printed return address from her, and it was a letter sent off to a bank. And I looked at it, and it was sealed, and I said, "Oh my God, what is going on here?" And I had this sort of dilemma where I said, "Oh my, should I really open her mail?" Right? And then I quickly got over that when I realized that she was sending off a credit card application. And so I of course opened it up, and to my surprise, this is a picture of what was inside. You can see, 7-year-old Stu. She didn't just fold; she folded it into these nice little extra folds and put it in there. And this is what was on it. It says, "I am 7 years old. Please don't send me a card." And so I talked to her about it because I'm fascinated with the fact that she had the insight to do this, and it all comes back to, I'm getting a little off track here, but it comes back to a postcard I sent her was the first thing she received in the mail. So she has been checking her mail for the past 3 months, expecting people to send her things. I don't know who would send her things, but it turns out people do send her things, and I would just throw them away, but she would intercept them and read them. And she said, "Yeah, Daddy, the credit card company has been sending me applications for a credit card. It's kind of annoying, really." And so this is what she sent. So I, of course, thought this was brilliant, and I refolded it up and it's sent. So I don't know whether it's going to affect it, but this is an example of I'd love for the banks to forget about my daughter until she's 18, but she's already in the system and she's only 7 years old. I don't know how that happens. But when I trace it back, I believe it has to do with signing her up for a frequent flyer number. And it's a company that's been sold her information. They don't know what her age is, and that's sort of the other thing. But so some of these problems are very real, and she's starting to deal with them. Even at age 7. The interesting thing to me is that there are, as Lothar mentioned, things like the Fair Credit Reporting Act. There's a number of laws that prevent, actually the issuance of a credit card to her at 7. I hope, but this was, her response at age 7, and without any sort of legislation, she sort of came on this on her own. I, of course, think that that's because she's the most brilliant girl in the world, but I'm a little bit biased. So how does Google think about these things? A lot of, there's a growing sense and consensus on both sides of the continent that the right to be forgotten explicitly applies to data that's published by a user. So it's information that users themselves, post online. And Google has a suite of services, of course, that many of us are familiar with. There's our search service, but then there's also the many different platforms that interact with users: Gmail, YouTube, Google+. There's a whole series of things. I'll give an example here in a minute. But Google believes that users should be able to control and delete their data, and all of our products have that ability for users to delete the data that they publish on our platform. You can delete your Gmails, you can delete your posts. There are special provisions, even within Google+, for example, that allow you to lock a post so that it can't be forwarded. And that's an additional level of control that's available even beyond what you can have in an email system, right? Because anybody can forward an email anywhere else. But with Google+ posts, you're able to unlock them further if you'd like. In the search context, because it's the publishers of data that control what's there. In other words, the website owners that users interact with that control that data. The Google search is really just a reflection of what's on the internet. And we offer and respect a standard protocol called robots.txt that can allow owners of websites, either on a macro level or on a granular level, in other words, at the root of the website or on any particular page, to prevent indexing. And Google respects that protocol. And so, we believe as well that even though the internet, our search is a reflection of what's on the internet, that website owners may choose not to have that information appear in our indexing service, and that's what the robot.txt protocol does. And lastly, because of our focus on user rights, there's a group within Google called the Data Liberation Front, and they're available at dataliberation.org. This image here is the logo, and that's kind of what you get when you let engineers design their own logo. All of our services have this ability to what we call Google Takeout, which allows users, if they want to delete their data and just take it all with them. That ability is built into all of our products, and it's a core belief that we have. Any new product that's launched has to go through that process in order to make sure the users are able to take their data with them. This is an example of what we call dashboard, and I'd encourage everybody to look at it if you haven't. It's at google.com/dashboard, and it has a number of sections on it, but there's a Me on the Web section that will show you where your information is reflected on the web, where there are links on the web. And you can control, obviously, your profile within Google and things like that. And then if you click on the link over there about how to remove unwanted content, there is information about how to do that, certainly within Google services, but also how to go about approaching other, the billions of websites and computers that interact with the internet to be able to do that, and encourage them to help users respect their data. This is a relatively Google-centric product, and one of the beauties of the internet is that there's an ecosystem available to opportunities for entrepreneurialism, and I think this is a great segue into Michael's product, which is a much broader approach, and I'll let Michael talk about it, but there's a lot of opportunities in the ecosystem for great services like Reputation.com to be developed and to offer users greater ability and insight to see what's on the web and provide some advice on how to control it.
Thank you. So Michael, you're also on the way, coming from an industry perspective, but obviously from a different direction. Can you talk a little bit about your thoughts on the whole right to lead motion?
Yeah, sure. And I'm going to try to keep it really short because I think we should move to the kind of the panel version of the panel. So first, I was reminded because Lothar asked me in the green room before we met, I was reminded that a lot of people, or some people in the legal community still have a mistaken view about what Reputation.com does. We don't send cease and desist letters. We never have. We don't send takedown letters. We're a technology company. We're a deep stack science and technology company. We protect reputation and privacy through technology, and we're probably part of the first wave of sort of liberation tech. How many of you know what liberation tech is or have heard of liberation tech? Okay, good. So we stand for the proposition that you should control as much of your digital life as possible within certain very distinctive limits. I sort of wish, I like a lot of what Franz said. I sort of wish that Franz did not give this example, this heuristic example about the criminal who was rehabilitated, because I think that just doesn't go over in U.S. audiences, and I think we should go a different.
That's why I'm here.
But there are other examples I think that could go over in the sense that if you say, I think your Amazon example is better in the sense that if you participate in an ecosystem online and then you want to remove yourself from that ecosystem, a lot of us would believe that you should be able to remove yourself from that ecosystem within certain limits of technical feasibility. I think there are two things I'll say as a starting moment, and then I look forward to the panel because you have a lot of very good discussion already. First is, I'd love to hear from the audience. First is, it's an accident that the internet is basically an advertising industry, right? It's an accident of the internet's development. If you look at the first $1 trillion of wealth that was created on the internet, and you set aside the ISPs and the hardware companies, about 90% of what's left is advertising, which is not the greatest of all human achievements, right? And nobody who was at the Ur moment of the internet was like, okay, we're going to really be much better than NBC and Sony, and we're going to be a much better industry built around advertising. What's happened is that there's a very sophisticated group of ecosystem of venture capitalists and entrepreneurs who develop products that are free, and we use them to collect data, and then we monetize the data about you without your permission or consent for purposes you'll never know and can never identify. And that's the kind of, so it's an accident of the internet that the vast majority of wealth created on the internet is dependent in some way on the accidental or deliberate confusion of the end user as to what's going on with their data. It's an accident. And we didn't have to do that. Now, by the way, I don't think there's anything wrong with the advertising medium of the internet. There are amazing businesses and services that have been built on the back of this. But I don't think that we have to begin our understanding of what the world could be based on what the world is, whether from a commercial or from a regulatory perspective. Now, I am definitely an American. I'm an American in the sense that I usually look towards innovation and entrepreneurship and the market on balance to solve these problems. And I put my money and other people's money where my mouth is, in the sense that we have built technologies that allow you to control your personal data and remove your data from places from the web you don't want them, and allow you to control your digital life and prevent the collection of data about you in the first place. So one of our technologies blocks, I think it's now 180 of the largest ad networks from ever collecting any data about you or storing it in the first place. So you prevent the flow of data. You get some of the toothpaste back in the tube, and you also prevent the toothpaste from leaving the tube in the first place. So I generally look towards technology to solve a lot of these problems and commerce to solve a lot of these problems. On the other hand, when it comes to topics like the right to be forgotten, I'm glad the tenor of the conversation so far has been as rational as it has been, and as sort of reasonable as it has been, because Lothar and Franz did a good job of setting up maybe the Manichaean kind of poles of opposition. There's something fundamentally flawed with the way, I went to law school, the way lawyers set questions, right? Where it's like, there's a very Manichaean sort of good versus evil, black versus white way that we supposedly expose and exposit truth. And it doesn't necessarily result in a lot of truth. And this is a topic, like a lot of topics about what to do with data or copyright or whatever. I remember from the last cycle, copyright and Eldred also generated the same kind of vituperative kind of energy. Sopan did the same thing a few weeks ago. There's a lot of emotional energy spent and a lot of black and white energy spent on this stuff, and there doesn't need to be. I think we can have a very reasonable conversation as to what the future can be and whether you should deserve some control over some of your data under certain circumstances and so forth. Now, on balance, I generally believe that you should be able to do. I believe that I have kind of a true libertarian view on this stuff, which is to say that if you actually know that your data will be used in certain ways. Now, I don't mean you know because you've read through a disclosure document that's 100 pages long, but you actually know and actually cognize the fact that your data will be used in certain ways, and those data, by the way, will be used in those ways and not beyond those ways in very specifically delimited fashion, which is often something that we don't know today, right? So if you give the data to Amazon, it goes to someone else, goes to the third party, the train, the track becomes lost. If you actually know, then you're on the hook for the consequences. I think then that's real. I think most people don't actually know, and I'd actually hazard to say that nobody in this room knows. We are probably some of the world's experts on this topic, and I don't think that we truly know. And so there's a big gap. And so there's a libertarian notion that, or the statement that, you're using the service, then you're up to the consequences. Well, most people don't actually know how their data are being used. So I would like to see a world in which technology, maybe some very light regulation, allows us to control in a knowing and intelligent way how our data are being used. Now, last thought. There are analogs here. There's a lot of Sturman drawing about copyright and whether copyright protection would kill the internet and chill the internet. And I was, by the way, part of the original Eldred legal team when I was in college. I was the kind of little thought of a totem pole history researcher on that team. And we brought the Eldred case to the Supreme Court, and then we lost and so forth. We were very annoyed. But there was a big stir and drawing, and the idea was that, if we protect copyright in too much way, then the internet's going to be chilled and killed. And it turns out there's a lot of internet. There's a lot of internet today. There's a lot of media content on the internet. You can kill the internet. Similarly, trademark. There's a lot of trademark protection, and guess what? There's a lot of internet. And in the case of Germany, which does have a lot of protection for privacy and private information, there's a lot of internet. In fact, Germany is perhaps dollar for dollar, person for person, the powerhouse of e-commerce. To Lothar's sort of suggested point that e-commerce could be a way forward. So I don't want to kill the internet. I don't think the internet should be killed. Nobody here believes that. But we can see that water flows around these rocks, and there is wealth to be created and innovation to be had. Last thought on this is, right, a lot of lobbyists in Silicon Valley, which is still basically a media business, and I don't include Patrick in this group, but just talking about generally, a lot of lobbyists in the media business go to DC and they say, well, if you do X or Y, you're going to kill innovation. And innovation is a word that Silicon Valley lobbyists use to mean money. It's a code word for revenue. And because it sounds very important, innovation sounds very important. You go to Congress and say, well, this is going to kill innovation. And then Congress says, we don't want to do that. That sounds very bad. I don't want to be responsible for killing innovation. Innovation just means revenue. And right now, the kind of revenue that we know how to make most in Silicon Valley is advertising revenue, which again depends on the accidental or deliberate confusion of the end user as to what's going on with their data. So I think we can do better. I think there's all kinds of innovation that will come out of intelligent moving of the rocks in the river so that the water flows differently. And I'm very optimistic about the future, and I hope you will be too.
Thanks. I'm actually going to ask a follow-up for you, Michael. I think that I'd like to just kind of take a step down from abstract legal and technical concepts and talk about the core of what we're really talking about here, which is how does online data really potentially affect real lives. And that's, I think, something that you, Reputation.com, has to deal with daily. So I was wondering if you could kind of lay out some of the, without giving away names, some of the horror stories that you see how people's digital footprints actually end up affecting their lives.
Okay, great. So that's good. So I'll give a couple of horror stories, and a couple will be more horrible than the others. Because I don't think that we should focus on the kind of the most grievous heuristics. We should also focus on something that the sort of more low-level anxiety that affects a lot of people. So, there's a very sympathetic story of a young woman who was in a car accident, and she basically flipped her car, and she was not under the influence of any drugs or alcohol, and her car flipped, and there's a convertible, and her head was just chopped in half, right? And one of the guys from the California Highway Patrol took pictures of the scene, and which was his job to do, and brought them back to the police station, which was his job to do, put them in the system, plus or minus, which was his job to do, and then someone else at that station sent them to his friend or her friend, which was not the job to do, and then that person published them on the internet. And then people started sending him to her parents. And then, and so this is one of those things, these genies, that's very hard to put back in the bottle once you get it out there. And it's very, very difficult to do that even through copyright law. It was the subject of a very large lawsuit, which actually 5-6 years later has just been settled. But these photographs permeate the web now. And there are reasons for that. After realizing that they were fighting an uphill battle against the CHP, the family decided to go national with the story, and then that, of course, propagated the photographs further. So it's a dramatic story which tells a story of how something which now probably is newsworthy because all the stuff that happened wasn't newsworthy at the beginning and propagated through some small malfeasance by a few people, and then the internet kind of took over. The reason I don't like to dwell on that story is that while it's certainly very dramatic, it's certainly very sympathetic, which assists the argument that I often stand for, it's also hard to relate. It's not a relatable story. Most of us will not have such a tragedy happen to us. Most of us will not have such a thing. And here are the things that are important about that. One, she was not responsible for the posting of her photograph, but she was dead. And a lot of people sort of knee-jerk react and say, well, people are responsible for what happens to them when they post things to the internet, and then the internet exposes them. Well, in this case, clearly she was not responsible. Clearly her family was not responsible. Interestingly, and also by the way, the interesting point of law here for the lawyers in the room, which I think is probably all of you, she had just turned, I believe, 18. And in consequence of her being majority aged, she was not able, she had no standing because she was dead in front of the court as to the rights of her publicity. Now, isn't that retarded? Right? And so, anyway, the law was about to change. The CHP finally said, okay, we'll make a huge, settlement. And the law was about to change, and it was very, very sympathetic. And the law was going to have to change to make that rectified. Now, that's kind of the one side of the story, very, very, very dramatic story, and thank God that doesn't happen to most people most of the time. But here's the kind of the low-level stuff that affects all of us. All of us are having our digital DNA used and mined in ways that we never knew would happen, and we never signed up for in the first place. So I see a world in which, and by the way, Google, I think today or yesterday announced this very interesting program where they're going to run an experiment where they're going to try to pay you $25 to see if they can, sell your data. So the idea is we're going to give you a gift card for $25 to see if they're going to, then that gives Google the right to sell your data and so forth. And I was asked by a journalist, well, what do you think the data is worth? I said, well, Google's gross margin is usually about 90%, so imagine it's worth about $250. We'll see if the experiment works. But I believe that that's a better way to do it, that there are companies that can share in the bounty of your data, whether it's medical data or banking data and so forth, and instead of requiring us to believe that there's this implied contract where we log onto the web and now everything about us is subject to the sale and use by people we never can identify for purposes we'll never know, with third parties we'll never be able to identify ever. If we describe that in a different context, if I told you there's going to be a world in which everything about you is known, and by the way, we know a lot about you, right? Everything about you is known, and it's going to be shared for purposes you'll never be able to identify or never know, you say, wow, that sounds like a totalitarian state. And that's sort of an accidental permeation of the web. Now, specifically, on an example of this, right now, the basic sort of objection that certain people have is, well, digital advertising is intrusive. Well, if I want to see Nikes and my wife wants to see Manolo Blahniks, it doesn't really bother me personally, okay? It doesn't really bother me that I get a certain ad that is probably more relevant. They're not always more relevant than some other ad. But what bothers me is what we called 5 years ago would be coming, and now we know is coming. The same data sets are and will be used to assess insurance premiums, are and will be used to assess access to health care, are and will be used to assess opportunities for finance and financial opportunity. And though Lothar correctly points out that there's some regulation on the periphery of this, but not at the core of what I just said, it's very, 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 very hyper hard to prove. I believe, and I'm going to say just I believe because it's a public forum, I think it was WellPoint is an insurance company, and so I'm paraphrasing. Anyway, a large insurance company a year or two ago was caught sort of red-handed, cutting people off for preemptively for healthcare coverage just as they started to show signs of getting sick. And they were caught, man, boom, red-handed. And there was some document that said, yeah, we are definitely going to be evil. And then someone, said, they found the document, oh my God, you're definitely going to be evil. And so they find this company, the company's moved on, but we know that insurance companies, which have to do this for their own commercial reasons, do things like this. Now, imagine the same thing happening at 10 times scale, and it's totally untraceable forever. Because we know from the internet that the 35-year-old healthy woman is friends on Facebook with the same one, the 65-year-old woman who shares her last name who's a fan of a breast cancer survivor page. And we know that 35-year-old healthy woman pointed her own browser twice in 1 month to a cancer treatment center website. And that same 35-year-old healthy woman received an email about cancer in the last 30 days. Now those 3 data points belong to 3 different companies, and they are separated and kept distinct by the grace of God and 3 founders right now who are behaving in a certain way that we probably approved. We assume we approved. But that's a very, very fragile separation. It's a very, very fragile bulwark against what we know is happening. We know the Wall Street Journal has now said that insurance companies are collecting social media data to make assessments about it. And by the way, they have to. It's commercially impossible for them not to. And I think there's something better that we can do. And I'm very very optimistic that we can. Is that responsive?
Thank you for that. So, I'm going to follow my questions. So obviously, the big balancing act here is free expression versus privacy. The European Commission proposals do include carve-outs for journalism, historical purposes, scientific purposes, and artistic expression. But the thing that I'm curious about, and which I addressed in the story I wrote this morning, is are we going to run into some definitional challenges? What judge or regulatory body can say who's a journalist, who's a historian, who's an artist? Even Google does research in artificial intelligence and machine translation using user data. So are they going to be accepted? So I guess I'm just curious, practically speaking, can we clarify these sorts of definitions and make sure we're promoting the public good of privacy without detracting from the public good of free expression? Professor Werro, would you want to start with that?
I'm not sure I can relate well to what you just said. I would have wanted to go back to the opposition that was clearly pointed out between the EU and the US. I think we should be clear on the fact that there is a total clash. And it goes back to attitudes towards the market, belief in what the state can do for you or against you. And I think that there's no point in trying to think that one has it better than the other. So Lothar has the faith of the convert. That's beautiful, believe that the US got it right. The problem is that the EU does not agree, does not feel that way. The relationship of a EU person to the market just does not resemble the attitude that a citizen here has or consumer here has to the market and to the beauty of the market of the ideas. Interesting juxtaposition, the idea that we would have a market of ideas. I mean, there seems to be an obsession for the market in this country that the EU does not have. Now, my point, the only one, is not to demonize the US or what it does. It's fine. Have it. Just do not pretend that this is universal truth. And when I see people trying to act against corporations that typically are seated in this country, they lose. So that's a thing that bothers me, that suddenly, in the name of something that is whole sacred, who would challenge the beauty of free speech? One is suddenly losing sight of the fact that this is not the only way to look at things, and that there are competing values that challenge the absolute nature of free speech as it is understood here. So to go back to Michael's point or challenge or observation that my example, he regretted the choice of my example. I want to briefly insist on it. First of all, I do think that this guy has a right to be left alone. I find that good. I don't ask the US to share that view, but this sort of puritanical idea that once bad, always bad, is something I do not share. Okay? One can have been bad and then move on. What worries me, and this is the reason I chose this example, because I think it's rooted in a certain understanding of how privacy ultimately works. It's an old example. The example you gave about the woman whose picture is taken is an old case of a famous Swiss painter, Hodler, who was snapshot on his deathbed, and the whole family thought it was disgusting because they were hurt in their feelings. They had just witnessed the death of their father, and they didn't want, just because he was famous, his picture to be taken and to be mediatized. So I insist on this example because my example of the former crook, I think, raises tremendous technological problems. How can I avoid to have Google keep on talking or remove actually that news? And how can I at some point say, look, what was newsworthy 20 years ago now no longer is? If I have the information, digital information allows to just jeopardize the actual right to be forgotten. So I don't mean to insist, but I think the example is interesting to the extent that technologically, I'm not sure we can enforce it. Sorry to not follow up on your question.
No, that's fine. Patrick, I'm curious what you think, given that I brought up the Google example, and as the European Commission sort of moves forward here, do you think that they will run into some sorts of challenges in figuring out how, in a practical way, they can define these rules?
Right, and that's certainly the crux of the issue. I mean, defining the right to be forgotten is still something that is a live discussion. The change from a directive, which has been in place from 1995, to a regulation is a completely new proposal in many ways. And for those of you that are that may not be as familiar with European law, there's two basic forms of European legislation. There is a directive, which is the proposed legislation that has been implemented in 27 different countries. Sometimes those implementations can be different. And the proposal that's on the table now is what's known as a regulation. And the regulation has what is called direct effect. And so it's just a single law. By analogy, and it's an imperfect analogy, it's the equivalent of passing a federal law in the United States. It has the same effect across the country. And so it's important to get this right. And we look forward to engaging in that discussion. The proposed regulation just came out over the, about 2 weeks ago. The thing to keep in mind, though, again, is that there is there's a fundamental belief here in both the European continent and in the United States about freedom of expression. That's important. And the United Nations Universal Declaration of Human Rights was very forward-thinking in that respect, and made a technologically neutral proposal when they said that in Article 19 that the freedom of expression is the right to hold opinions without interference and to seek, receive, and impart information and ideas to any media, regardless of frontiers. So the role of Google, again, is to reflect what's on the web. The horrible things that we're talking about here are really bad things. But it's not Google that controls those things. There are other websites that control those things, and that's the issue. It's important for the publishers to be respectful of that data, and for users to to have those rights. We, like any other company, have to respect the rule of law, and we are, of course, taking down results and doing things that we have to do when there are court orders and when the law so mandates, and we have a transparency report that's publicly available that shows worldwide when those takedowns take place and the type of nature of those takedowns.
Lothar, I wanted to ask you, part of your role, as I understand it, is to help U.S. companies as they're building intellectual property and products to ensure that it will comply with international law. So assuming that these rules do go into effect, I'm curious whether there's going to be a challenge for companies here to build products and privacy policies that are going to fit both sets of rules. If there's ways to sort of divvy them up and apply different rules in different places, or if they're just going to sort of opt to move in more toward more conservative rules, for the same reason that web app companies want to do an HTML. They do it once and be done with it.
The question how this would affect the internet globally operating companies who are basically taking their products and developing for the U.S. market, they get adopted in Europe, even if the law is differently there, and then it's very difficult for European regulators to enforce their laws. How that would play out will depend how it's going to be enforced. That's why there's so much focus in this regulation about whether there's going to be an EU-wide sanction regime whereby companies would be fined by turnover, which for some companies would be billions of dollars for a violation of privacy laws, which is a very scary thing. The reality is that Europe, with its relatively broad laws in the past, has not enforced it much. I say the first 30 years of privacy laws in Germany, I mean, we taught it at school. When I clerked for a court, I had some cases on the table. It was a complete non-event. Damages weren't available. We have no class actions, and the regulators did nothing. So 30 years, there was just not anything done about these very, very broad, restrictive laws. Similarly, with the cookies regulation, I think cookies have been prohibited in Europe, required affirmative opt-in consent for most of what people do with cookies forever. That's always been the law.
then a European directive comes and say, well, you can place the cookie with opt-out, and people didn't even comply with that. And now there's a new directive that says we really, really mean it, and people have to really, really, really get opt-in consent. Now nobody's doing it either. So I think that the European approach, having these somewhat unrealistic, super restrictive rules, and then not doing anything about enforcement, would probably lead to, unless that changes, that companies here in the US will still do whatever they want, and the European users, which in a democracy should be heard, are adopting these services, possibly because they don't understand them. That is certainly a risk. But I think that would be my practical forecast. Now, to go to your earlier question then, and also pick up on the fact how would this actually work, or what would the effect of this be? Would it be very difficult to administer this right to be forgotten? I think all the examples that we use could be solved with existing European laws. The guy who wanted to be forgotten can already assert the existing European laws and say, can my name be mentioned in the newspaper? Most of the time in Europe, they don't put the name into the newspaper. We don't. I mean, here in California law, sex offenders can be looked up on the internet with their address and so on. That's something we don't do in Europe at all. And that's already these cases. Most of these cases can be solved with the existing law. Also, the examples that you mentioned, Michael, there were these possible abuses of health information. We have HIPAA on it, and I think it is somewhat confusing if we use examples where companies break the law that already exists and then make an argument that the law needs to be changed. I think that's just a matter of enforcement. I think most of these cases can be solved with existing laws, and I don't think this right to be forgotten needs to be introduced. I think the big change that this right to be forgotten, as it is in Article 38 or so of the proposed regulation, the big change will be that it will allow people to go after the platforms such as Google, Facebook, and so on that are content neutral. They're not publishers. They don't typically make the decision to publish things, but they allow other private consumers to publish. And the law would then, the way it reads right now, is that a platform operator would have to go into individual users' accounts, their pages, their Twitter accounts, their whatnot, and ask the platform provider to pull things out there. I think with cloud computing companies where they allow Dropbox and other things, Mega Upload, although that didn't go so well in recent days, it seems. But these companies, they would be somehow required to go into user accounts and find things, which is a privacy intrusion right there. And I think that would, to your previous and to the current questions, I think that would be the biggest challenge to find rules for that. Now, I agree with Professor Werro, who said earlier we should trust judges that they can work it out. I agree with that. I mean, this is not inherently a completely different area. But I just don't see the proposition is made that this is necessary. I think the existing laws protect people in most cases where the law is not enforced. We don't need to pass another law. We need to start enforcing it, or trust technology solutions that help with it. Trust the marketplace. Pause companies, Google has been referred to a couple of times just because you're in the panel. There's a lot of other companies you shouldn't be singled out. But Google is addressing it because the users care about it to some extent, so they will do that because that's what the users want. But I don't think the case is made that we need to dramatically change the law, do away with free services on the internet that are advertising financed. There are paid TV services and there are paid services on the internet, and the users get to choose. I don't think the case has been made that the data collection for marketing purpose really hurts people. We can point to particular examples, and in these examples it's usually criminals, ID theft, the government being aggressively enforcing things that they shouldn't be enforced in the first place, and then some kind of creepiness factor that makes us uncomfortable. But I've not seen the case made how this amassing of user profiles and advertising and so on hurts people, except in circumstances where somebody's breaking the law anyhow. And then I say we need more enforcement and we need more education. I agree with that too. And maybe people should not take driver's licenses anymore, but really get a license to go on the internet because they don't understand these technologies and how they can hurt themselves. Maybe that's what we need to do, that people get more responsible and get more educated on it. I'm wearing one t-shirt here, Zynga. It's a social networking gaming platform. It's very interesting. It's also very complex how they process data and so on. So they created a little privacy game where people can learn how their data is being processed, which I think is a great idea. And I think that might be a solution to get people more educated so they can make choices about it. I'm personally not worried what Amazon and my bank is doing with the data each other. I'm a little more worried about identity theft, people losing my data. I'm worried about people lying to me in their privacy policy. That's certainly a concern. And I think I'm worried sometimes about the government, what they will do to me if they knew where I parked incorrectly yesterday and so on. And I think there's other solutions to go after those kinds of culprits and not just do away with Web 2.0 as we've come to appreciate.
Does anyone else have any different response or want to respond to anything that Lothar said there? All right, so we're about 15 minutes to the end. So we're going to invite anyone in the audience to come up. There are microphones on either side if you just want to walk down. We'll start over here.
Just say one. I'm Fertik, so Tech Freedom, is it on now? I could ask a lot of questions for this panel, but let me just take one. Franz, we just went through something here in the U.S. where not only was it a really terrible copyright bill tried to be pushed through, but it was done so by people who, by their own admission, very proudly said they had no clue how the internet worked and what it would actually mean and how we would implement that. And so you can understand why some of us, perhaps all of us here today, were a little sensitive and maybe alarmed to hear you say you're, quote, not a technical person and you have no idea how the right to be forgotten would be implemented, but you're sure that we need to have one and the law should mandate it. So my question for you and for everyone else here in general is, it all sounds very well and good in theory, but what does it actually mean in the real world where intentions don't really matter, because what really matters is implementability and consequences for users, and in particular for the ecosystem. I'll just add very briefly to on top of that in response to Michael, I'm a little surprised to hear you say that the internet is just accidentally an advertising-based model, because all media have been accidentally advertising-based models because of the economics of information for centuries, because that's how information gets funded, because its marginal cost is zero. And so media...
I'd like to question that the internet is good in the media business. You just said that it's not accidental that the internet is a media business because it's a media business. You said something to
producing content, like producing magazine content and TV content, other sorts of content, is subject to the same economics, and they have fallen into advertising models not because they want to, but because of the economics of it. So that's one of the consequences that I'd like to hear talked about, which is not just the practical and technical, but the economic.
You're getting assuming internet for just replacing content.
Well, all I'm suggesting is that that's an economic conversation, and to assert that somehow this is just an accident and we can wave a wand and find a different model for the internet that doesn't require advertising, and where the consequences of, for example, many right to be forgotten don't really matter because we can find other revenue streams. That's a very tall assertion, and I think it would really be incumbent on you to suggest how that would work.
Amazon, Zynga,
Yeah.
eBay.
Right. So anyway, practical consequences
That's
of
$100
the
billion
trade-offs.
I just asserted. Okay, quick, move on to Professor.
Just thank you for your question. I think it's a great one, and I confess my ignorance right away, and I'm happy to repeat it. All I am struck by is the fact that a certain number of values of entitlements have been around for a long time and still seem to be in the air. 78 or 80% of the Europeans asked if they want to have more control over their personal data, say yes, I want to be able to go after what's out there and that I do not control. And I just want to suggest that just because we have new technology does not mean that we need to say, oh, well, there's nothing we can do. It seems to me that we can reflect on a certain number of preoccupations. When I see Facebook users be essentially the targets of advertisement that they don't even realize, I find that problematic. Oh, but you're free to open an account on Facebook. No, I'm not. I practically am not. I am because I'm an old curmudgeon, but none of my kids is able to afford the fact of not having, and I think these guys should know what is going on Facebook. They should have a way of realizing that they are actually being exploited and pressed like lemons, that they're interesting to the extent that they provide naively information, and that this whole thing that's called a social network for friendship is actually a huge commercial enterprise that makes money with them. So I admit that there are huge technological problems which I do not master, but I think my concern is a fair one.
People said the same about soda. They said coffee might have to be protected, someone else will figure it out.
Wait a second, so there's a frailty, we're at the law school, right? Werro, you're a lawyer, right? And so there's a frailty, and you come from a very libertarian, kind of point of view and stuff, and I get it. And there's a frailty where you have a bunch of lawyers or legally trained people who are trying to develop regulation outside the context of engineering and so forth. But it's also one of the big frailties of internet discussion that engineers kind of have one set of conversations, usually with one another, and lawyers usually have another set of conversations with one another. And so, you're right, the devil's often in the details, but that's true with any piece of regulation. And unless you're just anti-government or anti-law, you understand that as part of the discussion of any kind of regulation of law. And it's important that we go lightly and gingerly and intelligently, and it's important that these laws not be written just by lobbyists or one side or the other, or by people who are informed. Unfortunately, actually, comparing US and Europe, and it's a shame in the US ever to cite Europe as an example of anything. Let's just sit do it for a second. In the US, basically our governments are run by lawyers, right? Including lawyers who govern these topics. In Europe, there are engineers very, very closely involved in a lot of these topics. So I don't think you have to be an engineering expert to make a statement about rights, or an engineering expert to make a statement against the law.
So here, please.
Hi, I'm a journalist, and as a group, we tend to be very self-absorbed. So I'll offer a couple of occupational observations in hopes that they may be pertinent to the discussion. One is that I have never encountered in more than 30 years any problems with ground rules with people, what's on the record and off the record, until I started dealing almost exclusively with very highly paid, influential people whose whole living is based on their public image and manipulating public opinion, who seem perfectly happy to give presentations at public events and then claim to be shocked that somebody might be sitting there reporting to the world, notwithstanding that half the world is blogging. And this is, and the other half is tweeting. The point, if there is one here, is I think we're dealing in some ways with two very important classes of people. So the point is, I've never had a problem with ground rules with people with language problems, with people who clean toilets, who don't know how to deal with the media. It's only a problem with people in a very rarefied world. I'm sorry. The point here is, if there is one, is that you've got a small group of people who's very publicity conscious and whose whole day revolves around, or ought to revolve around, controlling the information about them. And you've got a whole other group of people that is presumably more or less clueless. And maybe these need to be treated in somewhat different ways. The other observation I'd make is that it's an interesting personal experience to go from spending decades having a vested interest in disclosure by the pound, and then having Block Shopper post the purchase price of a house that one's inherited on behalf of a number of heirs that could only be of interest in a neighborhood where one hasn't lived for decades, and become the object of God knows whose kidnapping fantasies or financial planning and marketing designs.
Anyone want to react to that? Okay, we'll move on to Jeff.
Is it okay to ask an actual question, or do I have to do that?
Please do.
Okay, Franz, I think when I came in, you were saying that you believe in the right to be forgotten because you believe that bad people can become good.
Yep.
But if you erase the the past from the internet. You're not really affirming change, are you? I mean, change means we have to be able to see the whole process. So is it really affirming change to erase history? That's a principle, not an implementation detail. I can figure out how to do that.
I don't want to erase history. I think in history, including the history of people, is interesting. But there comes a point where their personal identity no longer requires publicity because time has moved on. So we want to know that at a certain time, at a certain moment, there were certain people who were engaging into certain things. But if those certain people are still around and have changed their lives, I do think that their dignity entitles them to respect to the fact that what they used to do is now in the past. I'm not saying that it is something easy, and actually the enforcement of this right to be forgotten is never given as a matter of automatic application of the right to be forgotten. There's always going to be a balancing out of competing interests. On the one hand, we want to know what has happened. On the other hand, we have this difficult task of engaging into weighing whether the private interest of a private person is now competing in a significant way with that public interest. And I'm not too alarmed at the idea that we can find a line, that we can find, because often there's a fear that there would be a chilling effect. What are journalists going to do if they can't just systematically say exactly what's happening? Well, they may engage into weighing and to saying that this is here perhaps not as newsworthy. And I think the notion of newsworthiness is important. We fought for free speech in order to ensure democracy, in order to ensure that there would be a solid public debate where disagreeable things would be said. And I don't want that free speech that is so valuable be transformed into a weapon for massive corporations who get larger and richer every year. It is a confusion here in genre. Free market, free enterprise should be kept separate from free speech. So there's a balancing activity here, which I think we can engage in. Over here.
At one level, the discussion about the right to be forgotten has to do with about setting a baseline of privacy controls that would exist sort of across the internet, so you don't have to go side by side and scrutinize the inscrutable privacy statements, and you just have the sense of that this part of my data will be protected in this way. And I think, Michael, you spoke to this, and so what I'm wondering then, if the right to be forgotten is not the right regulatory mechanism to ensure this baseline of privacy. And given the fact that there are incredible financial benefits to data retention and to sort of the cross-pollination of data between sites, as was again brought up with some of the parade of horribles about merging data mining and how this could be used to keep people out of insurance pools or what have you. I mean, the idea is that there's a lot of money to be made from the data, so if we're not going to use this sort of regulatory mechanism of the right to be forgotten to ensure a baseline of privacy, then what might be some suggested other alternatives to this? I mean, they could be regulatory, they could be private.
I mean, I would say we go to the evil. So if your problem is that insurance companies should not be able to kick people out because they're sick, then we need to regulate insurance companies. I don't think we need to regulate information. If we have a problem with the fact that criminals shouldn't be named in newspapers, and I agree with you personally, if I read a European newspaper about somebody without the name in there, and then I read it here in the US with the name, there's no additional information to me that I know who that is, except that I can look their picture up immediately on Google Images and so on and find something out about the person. I think that could be separated, but let's regulate newspapers if that's important to us. But I'm against the notion that we then have to create this really broad new law, which will be very difficult to implement, where we haven't really made a case for that is the problem. I think the problem is in all these other areas. We can limit the government what they should do, and there's a digital due process coalition that helps a little bit rein in what we've done here after 9/11 with the Patriot Act, and we started regulating insurance companies. We have HIPAA, Health Insurance Portability Act, that has privacy protections. I think that is the answer.
So on exactly this point, so I think it's very easy for us, to have this sort of Manichaean debate between kind of, business and the law and regulation or something. So I was just, and I'm going to say it, I was just in Davos. And in Davos, I was part of a discussion with very, very, very senior, including chief executive representatives of very large companies that have enormous amounts of data, as much as Facebook and Google does and so forth. And a lot of them are looking for either intelligent, uniform regulation that allows them to know how to operate, or allows them to use their data in ways that they're not now allowed to do, or some set of very clear norms that have yet to emerge from business, which I'm also very happy to support, around, for example, very hyper clear, easy, and comprehensive transparency around how data are being used. So even they will say, look, in a given course of a week, we might query someone's bank account 40 times as part of the transaction universe that we're part of, and it doesn't make sense to get approval every one of those 40 times from the customer to allow that to be queried, but we need to query it to do our business and our job in ways that are very successful in 30, 40 years of history have allowed us to do. However, it would be useful and interesting, they say, if we could have some red light, green light, good housekeeping seal of approval from some third party. It could be a nonprofit, it could be whatever. It could be, I know there's an effort at Stanford Law School now where there's a kind of an attempt to normalize in a red light, green light way some privacy policy information. A very easy, simple to use scorecard that says, yes, we're using data in ways that are as described, that are delimited, and we can confirm they're delimited so that when we send data to a third party, it's actually not going beyond their hands, and we know that. There's a kind of audit trail there. And it makes it very easy. So there are a lot of ways to kind of get there, and I just want us not to think that the alternative to the status quo is Stalinism. You know what I mean? There's like this view that some people have that it's like anything that's not exactly what's today is just going to result in the death of the web. It's not true. It's never going to happen.
As your answer suggests and the question suggests also, I think we're challenged and we're faced with a new problem, which is the fact that we have come to an age where forgetting is increasingly hard. And this is not very human. In my humble, non-techie perspective, I find that to be a little scary. And so we need to realize that the internet is doing things to us that we are not yet used to. It used to be that one could tell a story and then human memory is being what it was, we would forget. Now, there's a threat that we won't forget, or that it comes. And here I read the guy who just wrote a good book, I think, about, delete, Meyer, whatever his name is. Yeah. I think this is what we're faced with. And I do not claim that the right to be forgotten is this wonderful, powerful thing that we should apply blindly. No, but let's realize, let's be creative about what's happening to us.
I just want one point on your story. You could have gone into the archive of the Neue Zürcher Zeitung and you would have looked up that story about this person before too.
That's a very different ballgame.
It's more efficient what we do now, that we can click immediately, and that's progress and that's innovation, and we cannot stop the information age with regulation. But I think the case is not made that any of these examples require the right to be forgotten, because I think the existing laws cover all of those already. Whether the guy is named or not, that's existing law. That's not the right to be forgotten. The question is whether you can go and burn old newspapers so that people forget. That's something that comes from George Orwell. That was one of the things the Ministry of Information does in this story, that they change the history records of things. I don't think there's no case made for that, but we should take no questions.
Yeah, we're over time, but it looks like just one more question, so.
Thank you. I have three quick comments. I'd like to get some reactions to them. First, I have to dispute the point that content and the internet are all about commerce. I'm unaware of the advertising model for Wikipedia, and I'm unaware of an advertising model for the earliest skyrocketing popularity of Facebook or even of Google search. I think there are a lot of examples where people come to and populate and build up structures on the internet based on content that have nothing to do with advertising or revenue. But I've noticed here a little bit of discussion that's similar to a lot of the discussion over piracy. Everybody starts out saying there are these bad things called piracy, and you start looking into it more, and then the discussion more. But there are people making a lot of money out of this, and that's what we don't like. And they're really profiting from your information, and that's a problem. To me, that's a separate question entirely from whether there is a problem. Whether somebody's making money is a separate question. But the point I'd really like to get to is this. I think that this concept is fundamentally extremely pernicious. There are whole countries and whole societies that would like the world to forget their histories. This country would like the world to forget what we did to Native Americans. And Turkey and Germany would love for people to forget their histories, so much that there in fact is the political phrase, never forget, that has a point. The same thing is true of, I'm sure Supreme Court Justice Hugo Black would have preferred that people not have known that he was a member of the Ku Klux Klan. I'm sure that local politicians would like for people to know that they didn't have certain financial interests. I'm sure that high school principals would like for people to know. So it goes on down the chain. I don't think there's any stopping point. And I don't believe that judges can be entrusted with the determination of when something gets forgotten, who gets to forget it, and what gets to be forgotten. So I really would like, I think for Franz and Michael particularly, to respond to some of these. Thank you.
I'll offer one comment. I know it was directed at Franz, Michael, but I do want to offer one comment. There's a lot there. The freedom of expression principles are so critical to many of the democratic institutions around the world, and that's something that we certainly need to preserve. But the comment I really want to make is on the economics, because there has been a lot of discussion today at the panel about economics and how do we value it and the money that's made. It's actually a fairly new science to look at the internet economy. Traditionally, people would look at the valuation of companies that are publicly traded and sort of extrapolate and say that's the money that's made. The Wikipedia example is an excellent one. If you take any GDP measure and try to apply it to what Wikipedia brings to the world, that value is zero. And that just doesn't make intuitive sense to us. And so, for those of you that are here that are looking at opportunities to study economics and the internet in the future, there's fertile ground there for work to be done. We've just published a website as part of Davos called valueoftheweb.com that hosts a number of studies on the value of the internet economy. It represents, on average, among the developed economies, 3.4% of GDP, according to some of the analysis that are fairly new. A lot of opportunities to look into that. And that's a little bit off topic in the area of right to be forgotten, but a very relevant one when you put it in the context of economic value.
I think your I'm not placing you. Okay, I think your questions or statements were very good, and obviously very passionately and felt, right? And there are two ways to kind of go about it. So, you gave the example of America wanting to forget about its treatment of the Native Americans, and like if you ask me if like I'm on the other side of that topic, I'm just not. You know what I mean? I'm just not on the other. I don't want America through this thing that we just call the right to be forgotten, which has to do with your personal data and your information, to translate into our being able to delete the history of the sad March of the Cherokee. It's not connected in any universe. So it's important that we look at this like any other topic, which is a topic of intense complication and complexity, and also a topic of a place where we can't agree. I guess I'm just more keyed up about the idea that if you decide that you want to post a picture to 3 friends on a social network, you should be able to remove that picture. I think that's a more basic starting place of this statement. And if you really kind of take I've never met someone who really stands for what they think they stand for when they say they don't believe in privacy. Because I've offered at different times to really take them to that on that question and offer to just experiment with their lives and publish everything about their lives if they like, you know. But they've never taken me up on it. And so I think, you know, there's this heuristic that people, you know, and I went to law school. I just, you know, the least fun panels to be on in some ways are law school panels because they're always there's this notion that we're taught in law school that like, you say absolutely it is true in all circumstances, and then the other guy will say no, it is never true in any circumstances. Then the truth will emerge. And that's just not true. It's just false. And it's this oppositional approach.
Why do you say that so absolutely?
Yeah, okay, fair enough. So I just, you know, most of the time, I mean, there's a different way to go about this, and I think your point of view about never forget and always remember is very well taken and well felt and well articulated, and I can't disagree with it. I mean, as you stated it, right? But I'm not, you know, the opposite of the opposite of the right to forget is, or the right to be forgotten is not, or the consequence of the right to be forgotten is not that, like, you know, Hitler wins. Like, it's just, you know, it's like, holy crap, well, that sounds bad, you know. So I guess I'm against this thing, you know. So it's just, you know, it's just like, it's always like that. And, you know, and it's like, and by the way, this is like 99% of us in this room would say, well, Fox News is doing one thing, and CNN is doing the other thing, and like Mitt Romney is lying, and Barack Obama is saying another thing else. It's like, let's not do that ourselves. Like, in order to have this conversation, let's move beyond that the kind of Antipodean, Manichaean kind of debate that we have accused public figures of having. Let's just have a real conversation, and then we can maybe govern ourselves better. Also, just a point, like, Baron, I stand for commerce on this topic. Like, I'm the guy who built a company standing for the idea that we can solve this in the free market, and we should be able to solve this in the free market. So, you know, let's stay optimistic.
I don't want to be the socialist Bolshevist of Europe here. Commerce is wonderful and is, of course, essential. I would like commerce to be honest and to sell products for what they are and in all transparency. When I hear, you just spoke about Fox News, and I'm being remembered of this dark episode of this New York governor who was caught, you know, against prostitution. Of course, he's caught with one. And then one goes after the woman. Of course, she makes $2 million in one day, so she cannot complain about her sudden publicity. But there goes the grandfather of this woman, who's being chased somewhere in New Jersey at 9 o'clock by Fox Channel, and who says, I've got nothing to do with this woman. He's the grandfather. And indeed, on earth, why would you not leave him alone? Of course you know that chasing the grandfather is going to make audience. It's not about free speech, it's about something that is presented as free speech that is actually making bucks in a cheap way. So, why do I want judges to balance out these competing interests? Because they're the only ones I can trust on earth to try to engage in a reasonable conversation about what can be done, until when, and how far, without threatening something that's on the other end of the line. And I do believe, or I feel in what you say, that indeed there's not a black and white thing. It's difficult stuff, and the best way to go about it is to agree that maybe there's a middle ground. And people who are entrusted with deciding what the middle ground is are the judges.
All right, on that note, thank you everyone for attending.